You understand I'm not bound to follow that. I could sentence you all the way up to the maximum possible penalty.
The firearm in this vehicle was like a folded up black shotgun on top of a black jacket in the back seat of it.
I feel pretty stupid sitting here.
What you just watched? That was the moment Ashley Avery realized his plea deal wasn't a safety net. The judge made it clear she wasn't bound by any agreement. But what led a man with a folded shotgun in his backseat to a simple drug charge? This is the state of Wisconsin versus Ashley Avery. It looks like a standard possession case, but it's really about a man trying to outrun a 5-year cycle of warrants. When District Attorney Kevin Schmidt described a folded-up black shotgun hidden in a modified truck, Avery faced felony prison time. But why did the prosecution suddenly back down? Timeline shifts and a bizarre vehicle modification change everything. At stake, 30 months of jail time affecting Avery's chance at a clean start. If you want to understand how courtroom psychology catches the lies most people miss, hit subscribe for more real-life justice. Let's go back to the beginning.
We will go on the record in the matters 21 TR 176, 177, 24 TR 798, 25 CM 133, 26 CF 33, and 26 TR 238, State of Wisconsin versus Ashley Avery. This date appears through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel in person. Mr. Avery appears in person in custody. We're set today in this matter for a couple things, some of which Mr. Feliski represents Mr. Avery on, which is the 26 CF33 matter. And there are the older cases to address a fail to pay warrant and have a hearing, and then that ticket that just kind of is floating along with the 26 CF matter. Mr. Feliski, at the last hearing, it was to be a waiver of preliminary hearing. You were running a little late and you were not able to meet up with Mr. Avery to thoroughly go over all of the information. It appears you have done that now, since I have a waiver of preliminary hearing document in my file. Is that correct?
That is correct, Your Honor.
Mr. Avery, did Mr. Feliski thoroughly go over with you that right to waive a preliminary hearing?
Yes, he did.
And so now you understand everything as it relates to a preliminary hearing?
Yes, I do.
You understand your rights, you understand the ramifications of waiving one, you understand all of that?
Yes, I do.
Did you sign that document?
I did.
Do you understand that waiving your right to a preliminary hearing is forever and you can't get it back?
Yes, I do.
Has anyone made any threats or any promises to you for you to waive this right?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes, I am.
And so you're asking the court to continue and to find you competent to do so?
Yes.
I will find you're competent to freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind that matter over. Information, Mr. Schmidt?
I filed it yesterday.
It is pre-filed. He understands the charges and the maximum penalties.
I believe so, Your Honor.
Waives formal reading.
Waived.
Not guilty pleas will be entered on his behalf. At this time, what is the agreement that the parties have reached?
Thank you, Your Honor. The parties have reached an agreement for Mr. Avery to plead to count 1 in the complaint as amended to a misdemeanor possession of THC, along with a plea to count 2 as charged, the possession of drug paraphernalia. The parties are making a joint recommendation for 30 days of jail on each count to run concurrent, along with court costs on each count. I've completed a plea questionnaire with Mr. Avery, and I filed that document. It is number 20 in the file.
What is the jail credit that he has of today?
Your Honor, Mr. Avery has been in custody since I have here from the jail roster, March 21st of this year. So
the 30 days would be time served.
It effectively would be time served, Your Honor.
All right. Basis for amending count 1, which is currently a possession of firearm, convicted felon to a THC.
Watching the body cam and seeing the various characteristics of the vehicle he was in, and the actual owner was nearby, pulled over right next to it, and the things he said, I think it's reasonable for the court to give benefit to the defendant that those circumstances he didn't intend to exercise control over the firearm.
All right. Okay. Formal motion to amend count one.
So made.
Court will grant that motion. It is now amended to a possession of THC simple. Mr. Avery, I have in front of me this filed copy of the plea questionnaire waiver of rights document. Did your attorney thoroughly go over that document with you?
Yes, he did.
And you understand it completely?
Yes, I do.
And that's your signature on the second page?
Yes, it is.
You're pleading guilty to 2 misdemeanor counts, one of possession of THC and one of possession of drug paraphernalia.
Yes, I am guilty.
All information on that document is accurate and true.
Yes.
Did your attorney thoroughly go over your constitutional rights with you?
Yes, he did.
And you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No, you don't.
You understand that by pleading guilty, you're waiving and giving up those rights?
Yes, I do.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
I do.
Do you understand the state would have to prove on or around March 21st, 2026, you possessed a substance, the substance was a controlled substance in it, which contained THC, and that you knew or believed that substance was a controlled substance containing THC? Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $5,000 or up to 6 months of incarceration or both? Actually, it's $1,000, sorry. You understand that?
I do.
And do you understand that with count 2, possession of drug paraphernalia, the state would have to prove the same date, the same time, the same place, that you knowingly possessed with the primary intent to use a container and a glass pipe to store and to inhale controlled substances? Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $500 or imprisonment of up to 30 days or both?
Yes, I do.
Do you understand that agreement that you've reached with the state?
Yes, I do.
Do you understand I'm not bound to follow that?
I do understand.
Said differently, I could sentence you all the way up to the maximum possible penalty if I thought it was warranted.
I do.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you review the complaint with your attorney and those facts alleged in that complaint?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did possess THC and drug paraphernalia?
Yes.
Are you pleading guilty because you're guilty?
I am guilty.
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or promises to you, Mr. Avery, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, I fully understand.
and voluntarily.
Voluntarily.
Are you satisfied with your attorney's services?
Yes.
He's done a good job looking at the matter and discussing it with you. Do
I feel he has.
you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to amended count 1, possession of THC, how do you wish to plead?
Guilty.
As to count 2, possession of drug paraphernalia, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 misdemeanor counts. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think the court should follow this for the THC, for what he's actually pleading guilty to today and sentenced on. I think that this jail is appropriate. I think the main thing that Mr. Avery will probably want to be careful about in the future is make sure there aren't any firearms in vehicles he's borrowing. The firearm in this vehicle was like a folded up black shotgun on top of a black jacket in the back seat of a truck. You wouldn't see it unless if you got in and turned around and looked. So perhaps he didn't do that. I don't think he placed it there with the presence of ammunition around the vehicle, and with the owner had modified the vehicle, like knocking out where the AC should be on the left to basically put in a spotlight to use by the side of the road, which kind of gives the appearance the vehicle's intended for shining and shooting deer by the side of the road. So it would make sense such a person who made a modification would just always have a shotgun in the vehicle. So I think it's reasonable to conclude he did not put the shotgun there. In fact, the owner of the shotgun complained that he'd like to get back at the scene with the deputy. And I think it's reasonable to conclude that he didn't intend to exercise control over it given those circumstances. Thank you.
All right, thank you, Mr. Felisky.
Thank you, Your Honor. I concur with the remarks of the state. I'll first, again, note the credit here. Mr. Avery was brought into custody on these charges on March 21st, 2026. As of today's date, he would have 31 days of custody credit. Your Honor, I do think that this is an appropriate agreement to resolve this matter. Mr. Avery has expressed some very sincere regret to me about not being careful and not paying attention to his surroundings. I think this was a powerful and hopefully a permanent reminder to be aware of who he's around, where he's going, the company that he keeps, and most importantly, to check and make sure that he's not around something he shouldn't be around. In speaking with him, Your Honor, one thing that did strike me is that he was initially planning upon his release to return back to his mom's address. That was where he was planning on essentially rebuilding, finding jobs, employment, housing, resources. But in reflecting on that and reflecting over this past weekend, Your Honor, he indicated something I think that speaks well to his character. And that was, if I go back there, Joel, I'm going to get right back into it. I'm going to get right back into the bad habits, the same bad circle of people, the same bad influences. I'm going to end right up back where I was before. So I can't do that. He's spoken to some of the other individuals in custody who have pointed him to resources available at Duluth. Specifically, there's a mission homeless shelter in the area that he is looking to transfer over into. He's planning to use that as a base of sorts to set up housing, resources, employment. He's looking into a potential job opportunity working on the Blotnick Bridge over in Superior, Duluth. All to say, Your Honor, Mr. Avery has had a lot of time here to reflect on what led up to this point, what he needs to do in this moment, and what he needs to do going forward to avoid ending up back in these circumstances. There was another remark that he made to me, Your Honor, that I think, again, speaks very powerfully to his character, which is that he wants to let his actions speak louder than his words. I imagine to some extent that has already come into play here. His actions have spoken for him. He's been in custody because of those actions. He is sitting here right now in Orange because of those actions. But I think it's the acknowledgement of that, Your Honor, and the understanding that there is a reason why I'm coming back here before this court, before any court. And in order to avoid that, in order to avoid taking up judicial resources, in order to avoid wasting my time, my life, so to speak, I need to figure out what the underlying cause is here. I need to figure out what's going on. I need to address it, however it needs to be addressed, but it needs to be addressed. I think under the Galleon factors, this is an appropriate agreement. Mr. Avery has already received punishment here in the form of the time spent in jail. I think that will be an effective deterrent towards him reoffending now or in the near future. Overall, I do think that this is an appropriate agreement, and I would ask the court to follow it. Thank you.
All right, thank you. Mr. Avery, anything you want to say, you want to let me know?
I don't want to sit here and make all the same promises I promised you before and say all the same things I've said before. I guess like Mr. Felisky said, I would just rather just do it rather than say it.
All right, I would like to see that too, Mr. Avery. This isn't a very serious case, and how it flushes out is different than what it first appeared like. So again, it's not very serious. You've already been punished. You've been sitting here for 31 days. So I'm going to follow the recommendation as it relates to both counts, except for the fact that I'm going to sentence you to 40 days of jail with time served, or with the good time, that's time served. So you're good to go with 31 days of actual jail credit. I'm going to assess the minimum of $200 DNA surcharge, only waiving court costs and fees. The reason I'm doing that is because you already owe the court $580.30, and that's what we're going to address here in a moment.
Okay.
And so now it's going to be increased to $780.30. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that route, or that right. I need DNA. The jail will make sure that they take that. You have the right to request it be expunged through a written letter to the Department of Justice. Mr. Schmidt, what am I missing on these matters?
Nothing from me.
Mr. Felisky?
I don't believe anything further.
All right, then you are good to go with those. as it relates to the other matters, the 21 matters and the 24 TR and the 25 CM matter, again, you owe $580.30 with this additional now $200. And we're stemming way back here. We're stemming back to 2021. These should be paid off. I appreciate that you're going to be released from custody and you want to go to Duluth, but I hope you can appreciate the fact that I will issue a warrant again and you will sit. You could sit up to 6 months in jail per count. And you have 1, 2, 3, 4 cases at this, and now 5 that this results from. It's very important that you get a job and you start making your payments. And I'm going to guess you have no ability to put any money down at this time.
Correct.
What I'm going to do is I am going to, you are in contempt. You're acknowledging you are in contempt. You're nodding your head up and down. Yes, you are, because you haven't paid or paid this off since 2021. And then again, you have a 2024 and then a 2025 that keeps accumulating interest. So what I'm going to do is I'm going to find you in contempt. I'm going to order 90 days of jail, but I'm going to stay that. Okay.
Okay.
And I'm staying that as long as I get your monthly payments. It's April right now. I'm going to give you a month. I'm going to say your first payment is due in June. Okay. Of $50 a month, at least $50 a month. If you can figure out how to pay it off sooner, I'd pay it off, Mr. Avery, because I think you understand me and I understand you. I think you understand a warrant will be issued and you will sit that time.
Yes, I do.
I don't want you to sit that time. And I think $50 is a reasonable monthly amount, correct?
Yes, that's fair.
Okay. But again, if you get a job and you have the ability to pay off $200 here and $200 there, I'd pay it off because I don't think you want to be seated in that chair when I'm going over whether or not you've paid or you've paid it off, right?
Right. I feel pretty stupid sitting here.
I don't want to see you there either. So go to Duluth, work with Pastor Jack, if that's your route, or go find sober living and go get a job and pay this off, because I'm going to tell you, and you know this too, warrants will find you.
Yes. Yes.
So that's where we are. So your first payment will be due by the end of June of $50 a month. That gives you time to get your life a little bit more situated and to get you up there. I agree wholeheartedly with your statements and Mr. Felicki's statements. Get out of Dodge, go find some other place, get people that can improve your life, not continue to drag it down. Okay. All right. I think that's it.
The decision is final. Ashley Avery walked away today with time served, but a strict payment plan is still hanging over him. But here's the question. Was this ruling a fair second chance or just another hurdle? Comment below, Team Judge or Team Avery. Can someone really rebuild their life while the system keeps adding more debt? If this case got you thinking, hit like. Share this with anyone who loves courtroom drama.